principle. So why is the weakening of constitutional property federalism a problem? Takings law has long recognized and welcomed the fact that property for federal constitutional purposes can mean different things in different states. So the freedom of the states to recognize different property interests and limit them with different regulations is far older than regulatory takings doctrine as a matter of both private and public law. So you can come up with a ton of examples thinking back to your law school days of state-by-state property variation. My favorite to teach is the right of publicity. So Bette Midler might be protected in California in her distinctive voice, but not in West Virginia. And this variation among the states in property coverage has been important in defining the scope of constitutional protection in each of the states. And so I've done some research on this topic. In fact, I've written a few papers on, of all things, street grading. So what is that and why should you care about it as a takings person? So in the late 19th century, a number of states began raising and lowering their streets in ways that did not directly appropriate property, but did drastically devalue it. And so this led to a variety of changes that you may be familiar with. One of them that I've written about is the insertion of the language "or damaged" into many takings clauses, into 27 states' takings clauses. But another response to the problem posed by street grading, where there were massive devaluations but no appropriations, was the invention of a new form of property interest, a new easement of access that became the property right that was then taken by these actions. And so I've written, again, several papers on this topic, and I would talk to you ad nauseum about them at any point. But what's interesting about this to me is that not every state recognized this form of property. So Ohio was the first. Many other states began recognizing this, but a number rejected the existence of this type of property. So there's clear state-by-state variation in the forms of and limitations on property that was accorded constitutional recognition. Another famous illustration of unique state property rights actually comes from the regulatory takings holy grail itself, Penn Coal, I'm thinking of course. And so this is the case in which Holmes, right, famously held a coal company's support estate, which is the right to cause surface subsidence, was confiscated by coal regulation, giving rise to modern regulatory takings doctrine. The support estate was invented in Pennsylvania to resolve chain of title problems, of all things. So landowners would transfer the surface estate to one person and the mineral estate to someone else without saying who had the right to either cause subsidence or prevent subsidence. So Pennsylvania courts invented this third estate, this support estate that belonged to the original transferor. And so this was a property solution to the problem. And so it was critical to the Holmes determination that that property existed and was rendered worthless. And although Keystone does change that opinion a bit, I do think it's important. There was always a reliance on Pennsylvania law and Pennsylvania law only. Keystone did not rely on the fact that nobody else recognized the support estate. So while many have criticized some forms of state property as being unwisely created or some state limitations on property as foolish, no one has suggested that we should eliminate variation among the states in constitutional property coverage or how property rights might be limited. To the contrary, it's been accepted for a long time that there are many benefits to constitutional property federalism. So our social and economic systems benefit from competition and innovation in property. This is a bedrock principle. It's democracy enhancing, right? So you can use political control mechanisms to get different property rules in different jurisdictions. Welfare enhancing too. So one of my favorite stories to tell about actually the street grading incident is that street grading, which was happening mostly between about 1830 and 1920, was usually a form of slum clearance. So it was pre-urban renewal, urban renewal. So one way to get rid of a slum was to lower all the streets so that people couldn't get out of their houses. And so by creating a new form of property interest, this was actually a way that judges sort of used property to address this inequity and enhance welfare. Finally, of course,